Hi everyone, and thank you for joining us for today's Use Laboris client webinar to discuss new rules for posted workers in the EU. My name is Annie, and I'm the facilitator for today's session. So today we will hear updates on the Posted Workers Directive from our lawyers in Belgium, France, Czech Republic, the Netherlands, Sweden, Germany, and Slovakia. So that will be it from me. I will then hand over to our moderator, Sophie Maes from Belgium. So go ahead, Sophie, you are welcome to start.
Yes, thank you, Annie, and welcome also from my part. As Annie said, I'm Sophie Maes from the Belgian member firm Claeys and Engels, and it is my pleasure to host this webinar on the new rules on posted workers in the European Union. New rules because the member states had to implement the new rules as a result of the revised Posted Workers Directive of 2018, and they had to do that until or by the 30th of July 2020. So we have 1 hour webinar, we have 7 speakers, 7 countries. So our purpose is to give you a high-level overview of the main changes. So who do we have here? We have several countries. We have France represented by Anne-Laure. We have the Czech Republic represented by my colleague Nataša. Then we also have Hilda from the Netherlands, Peter from Sweden, Julia from Germany, and Dancia from Slovakia. But before I start, or before we go to the different jurisdictions, I would like to give you a brief recap of what we are talking about in this webinar about the Posted Workers Directive and the revised Posted Workers Directive. Annie, if you could move to the next slide. Yes. So, the Posted Workers Directive, what is it about? Well, first of all, it is very important to note, if we speak about the Posted Workers Directive, it's about employment law. So we don't talk about Social Security, it does not relate to tax laws, it's about employment laws. And it's also about a situation of seconding or posting employees, and that relates to a situation where an employee who is in service of a home employer is temporarily sent on behalf of that home employer to work temporarily in another country. So it's very important, it's temporarily, and secondly, there is no employment contract, no employer in the host country. The employee remains in service with his employment contract with his home employer abroad. Because this is a temporary situation, and that is another tool we have on European legislation, is a Rome I regulation, then says, well, actually, because you work temporarily there, well, your employment contract remains governed by your home country employment laws. Because that could give rise to abuses and so forth, there have been in 96 an introduction to that, an exception, sorry, to that principle has been introduced, saying that even if your employment contract remains covered by your home country employment laws, well, there is always a hardcore of minimum laws that you also need to respect, minimum laws that apply in the host country. And the reason for that is to make sure, or to ensure, this very difficult balance between, on the one hand, the free delivery of services, and on the other hand, to avoid social dumping, unfair competition, and so forth. So that's the reason why in 96, via this Posted Workers Directive, this principle has been introduced, that there is always a hardcore of minimum terms and conditions of the host country that must be applied, even if our employment contract remains governed by our home country employment laws. Has been introduced by a directive, meaning that each European country has to implement it in its own jurisdiction, and that is where somehow, since 96, there were a lot of differences between all the different European member states, and where the Commission came to the conclusion that it was not enough. So in 2018, Posted Workers Directive have been revised in order to increase protection. So if we now summarize, and Annie, you can move to the next slide. If we now summarize what are these changes that have been introduced by the revised Posted Workers Directive, which on its turn the different member states had to introduce in their local legislation by the 30th of July from this year, well, they can be summarized in 6, I would say, topics. So first of all, first change is that those hardcore of minimum terms and conditions of the host country that apply have been extended. A very important aspect therefore is the concept of remuneration. Because in its original version, it was stated, or it was not remuneration that was provided, but it was the minimum rates of pay. Well, now this concept has been extended with the purpose to make sure that we have equal pay for equal work at the same place, in a sense that remuneration is not only the minimum rates of pay, but includes all mandatory elements of pay. And it is up to the host country to determine, based on its national law and practice, what are the elements that are mandatory and which must be complied with also for posted workers on their territory. So a much broader concept of remuneration than we had before. Secondly, if accommodation is provided by the employer, must be done according to host country standards. And then a third aspect that has been brought in as well is that if in the host country for the local workers, allowances or reimbursements of expenses for travel, board and lodging are provided for travel within the host country or from the host country if those employees are then temporarily seconded abroad, that these should then also be applied to posted workers. So first of all, this extension. Secondly, the CBAs, because in the previous version of the Posted Workers Directive, it was only mandatory to apply the CBAs in the construction sector. Some countries already went much further. Now this has been generalized for all posted workers in all sectors. CBAs that have been declared generally binding in the host country must be applied to posted workers. Third aspect, very important in the whole discussion, is again those allowances, discussion about reimbursement of travel and board and so forth. There it has been included now that in relation to expenses to come from the home country to the host country, whether or not the employer must pay for that, and we can think of the famous per diems that we in particular know in the East European countries. Well, whether the employer must pay for that, that must be determined according to the law applicable to the contract, so the home country laws. And another thing that has been introduced is, and which is important as well, because in the whole discussion to know whether the remuneration and all the elements that remuneration includes in the host country are being complied with, the question then also comes up, what about allowances, specific allowances that are being granted in relation to the posting? Can we also take them into account? So the principle that was already in the previous directive was, yes, they can be considered, unless if they would cover genuine expenses, such as expenses for travel, board and lodging. Because they cover expenses, they cannot be considered to see whether we comply with the required remuneration. Now, an additional thing has been added here now. If we grant allowances and it is not clear based on the terms and conditions that apply to the employment relationship, which part of an allowance is to be considered as covering expenses and which part could be considered as remuneration, well, then it's a presumption the whole allowance should be considered as expenses and cannot be taken into account. So what is important here as a message is that if you want allowances that they are not really covering expenses but should be considered as remuneration, it is very important to make sure that you document this in your contractual documents that you conclude in order to document the posting or secondment. Then next topic, and that's, I would say, one of the most important ones in all jurisdictions, and if we can now move to the next slide, please, is the long-term postings. Because what we have under the Posted Workers Directive. In principle, we have this hardcore of minimum terms and conditions that apply as of day one. For the rest, normally it's based on the law that apply to the employment contract. Well, there has been an additional term has been introduced saying that if your posting exceeds 12 months, so after 12 months, it is not only this hardcore of minimum terms and conditions that apply, but all mandatory terms and conditions of the host country will apply to the posted workers, so much broader than it was before, be it that there are still two very important exceptions, namely first exception, what does not apply after 12 months, or at least not based on the Posted Workers Directive, is everything in relation to the conclusion and termination of employment contracts. So in other words, the dismissal rules are still excluded out of this Posted Workers Directive protection after this 12-month period, and also including also non-competition rules. Second topic that is excluded is everything in relation to supplementary pension schemes that also remains excluded. There is a possibility to get an extension up to 18 months, but the different jurisdictions will give you more explanations about that, how you must do this. Other thing was already something which was introduced in another directive is this, but it's very important, this information duty of the member states. Member states must make sure that they have official websites where employers can find all information, and so that it's clear for them what terms and conditions they need to apply to their posted workers. Temporary agency work or other principle that has been introduced, principle of equal treatment, that it now also should apply to posted temporary agency workers if that would not yet be the case in the different jurisdictions. And all of this, also important, is temporarily not yet applicable to the road transport sector, because there it's the purpose of the Commission to provide separate rules for that. So that are in a nutshell the main changes that have been introduced in 2018 in this revised Posted Workers Directive, and that now the different jurisdictions had to make sure that those were also included in their own local legislations. If we can move now to the next slides. So they had to do that by the 30th of July 2020. As is very often the case, not everybody has done it. So we did within Youth Laboris, we did a survey within our expert group. We have a separate expert group on global mobility to have an overview of the countries that already introduced it. And you see it there. So you have in the more darker green, you have the countries which have been in time and have introduced it into their legislation, which are, of course, the countries we have present here today. But next to those countries, it's also applicable yet in Poland, Hungary, the UK, and in Estonia. And then, so actually up to date, so 11 countries who have implemented yet. And then you see in the more lighter green, you see the countries where there is draft legislation in place. So we may assume that the legislation will follow there very soon. And then we see draft legislation in Portugal, Croatia, Romania, and Finland. And then in the more darker gray are the countries who must implement it, but where there is still nothing. So that is in a nutshell the current status of the implementation. If we can move to the next slide. So that is just to show where you can find this, because if you click on the map, you will also have a short summary of the changes, and you will find this on our website of Youth Laboris. You find the reference over there on our dashboard, on our global mobility dashboard, which you can find in under the heading trendy topics. So that was it as kind of an introduction. So I'm now very happy to go to the various countries to have a look at the main changes, how this all has been implemented in local legislation. And Anne-Laure, if you can start with giving us some more information about France.
Yes, thank you, Sophie. So as you could see, France has implemented the directive back in 2019, And the main changes are related to the explicit introduction into our labor code of the equal treatment for posted workers. This implies, as of 30th of July 2020, an extension of the core set of French rules based on, first of all, a wider definition of equal pay. So indeed, posted employees should perceive the same amount of compensation as the local workers, including fixed, variable, in cash or in kind remuneration. And also we have a wider definition of business expenses. Equal treatment applies to all kinds of business expenses, meaning transport, meals, and accommodation expenses borne by the posted employee to perform his or her duties in France. The second point is that there is, after 12 months, like Sophie pointed out, the rules are going to be wider for long-term posting in France. After 12 months of segment, all French labor code provisions apply. So there are some exceptions which are important and which are indeed related to the conclusion and determination of the contracts, but there are also more exceptions in France regarding the changes of the contracts based on economic grants, also the transfer of contracts, and also a secured voluntary mobility scheme, which is an opportunity for an employee to work for another company for a certain amount of time. It also applies to provisions related to fixed-term contracts. So these exceptions are important, but the principle of applying all the French labor code provisions is new, and the scope of the applicable rules is very wide. So we can talk now about Germany. What is it like in Germany?
Hi, everyone. This is Julia from Germany, coming to you from Berlin. First of all, the rules which are included in provisions, administrative provisions, or statutory provisions that are now also applicable to posted workers have been extended. Those are specifically the rules on pay, including also overtime rates, whereas before it was only minimum pay that was applicable to posted workers. Also requirements regarding accommodation when this accommodation is provided by the employer, and rules on allowances and reimbursement of, for example, travel costs. It's important to note that this reimbursement cannot be deducted from the general pay paid to the posted worker. For long-term postings over 12 months, as Sophie has already said, all working conditions become applicable to the posted worker, which are regulated either in statutes or in administrative provisions or generally binding collective agreements. In Germany, for example, that would be regulations on parental leave or also on sick pay. This can be easily extended to 18 months, meaning the period during which all working conditions from those provisions do not yet apply to the posted worker. And in Germany, this is done by way of notification to the customs authority, which is competent in text form, meaning, for example, by email. This must be done in German and include specific details. It's also important to note that if you're intending to replace the worker with another posted worker who is going to be doing the same work at the same place, this will be included in the 12-month calculation. It's further important to note that if you're planning to conduct any kind of cross-border lease of personnel, there are new information obligations which you're going to have to meet. So now I give the floor to Hilda from the Netherlands.
Yes, thank you, Julia. Yes, happy to introduce to you the main changes for the Netherlands, whereby the Netherlands only managed to implement the new directive just in time. We also have an extension on the hardcore provisions, more or less in line with what we've seen in Germany. And in addition to these two that are mentioned on the slide, there's also a change where the minimum wage requirement as hardcore provision is replaced by remuneration, so the equal pay. So meaning that additional elements of pay, like a 13th month, would also become applicable. As we've seen in Germany, also here it's considered to be a same posting if you have a replacement of the same work at the same place. So that's something to really carefully consider. This was introduced obviously to avoid people misusing the revised directive and its obligations. Important aspect we feel is the allowances and this presumption of reimbursement of costs that Sophie explained before. The presumption means that you as an employer need to prove the source of the allowance and whether or not it's actually meant to cover necessary expenses or not, and that you need to detail what it's for. And if it's important to note also that if it's meant to cover necessary expenses for the secondment, then it cannot be part of the minimum wage requirement. In addition, for the Netherlands, the additional provisions that apply after 12 months is basically everything. For example, all the rules on sickness that we know here in the Netherlands, which are quite complex to observe. But the good news for the Netherlands, at least, is that it does not include the dismissal law. And why is that good news for you? Well, that is because, as you probably are aware of, that we in the Netherlands have a system where you require to get prior approval for dismissal and can't dismiss someone. It also doesn't include pension arrangement, nor does it include non-compete clauses. Then there's also changes for the posted temporary workers who, and it's important to note that they are entitled to the same pay as any Dutch temporary worker already from day one. So not just after 12 months, but from day one. And I mentioned pay, but it's more than that, it's broader, it's all employment conditions, including the applicable collective labour agreement and or any internal rules applicable within the receiver. So that's very important to note, which as this follows not from this directive necessarily, but from local legislation already. And then the extension to the 18 month, that's also an option here in the Netherlands, but it is very important to realize that you cannot have intended for the original posting to be over 12 months. That really needs to be less than 12 months for the first posting, and only if you have valid reasons to extend the posting, you can do so, but the total duration may not be over 18 months. I say you can do so, but that obviously also again requires you to notify and to apply for that extension. That in a nutshell are the most important changes that you need to realize. And I gladly hand over now to Petter in Sweden, where I think there's an issue with trade unions, if I'm not mistaken.
Thank you very much, Hilda, and you're totally right in that assumption. Hi everyone, this is Peter calling from Sweden, and just to follow up some of the main changes in Sweden following this directive, it's important to bear in mind, I think, that Sweden is a very unionized country where most employees are trade union members, and most employers are also bound by collective agreements. And this extension of the hardcore that Sophie talked about in the beginning will most likely result in increased possibilities for trade unions to take industrial actions to force employers to posted workers to enter into a collective agreement in Sweden. The reason because of that is there are no statutory minimum salaries in Sweden or other laws about allowances or a whole lot of other terms and conditions. All of these terms and conditions are regulated through collective agreements. And normally posted workers are surely not members of any Swedish trade union, so they cannot go on strike, of course, but other industrial actions, such as a blockade of a construction site or so, is are used from time to time by unions in these interactions. Another main change is that allowances may no longer be included as part of salary. It's something to remember when assessing what is a reasonable salary for a posted worker and what this worker may require, and also something for employers to be aware of, since the cost of allowances are normally higher naturally for a posted workers compared to a domestic worker in Sweden. The last two main changes concerns reporting of posting. From now on, it should be done at all time, no later than the first day of the period of posting to the Work Environment Authority. And a contact person must also be appointed throughout the entire period of posting. It is normally one of the posted workers, perhaps a site manager, for example, that is appointed. And this person is the one that the trade unions will most likely approach in the dialogue about entering into a collective agreement in Sweden. So I think that summarizes for Sweden for now. And with these words, I hand over to Nataša in Czech Republic.
Nataša, you must be on mute.
No, sorry for that. Hello, everyone, and sorry for this mistake. When I think about Czech Republic, we are mostly sending country. Therefore, the legislation concerning secondment to the Czech Republic, it was very easy for the Czech Republic to accept. And we did some changes, but mostly we copied the directive. One thing which I would like to mention, and which will be very difficult for foreign employer to send the employees on the Czech Republic, it's concerning the remuneration, because now with the minimum salary, we need to also provide a guarantee salary, which is very specific institution in the Czech Republic, but plus to all salary components, like the night work during weekends, state holiday allowance. But what is the, I could say, funny things that the foreign employers will need to calculate this allowance based on Czech regulation on average salaries, which is quite difficult. We also implemented in hardcore condition accommodation cost, and not very specifically, and I should say it's very unclear provision in the Czech law. As other countries, we have the long-term assignment that up to 12 months we could use the hardcore conditions, and with the special extension applied to the labor office, we could use the hardcore conditions up to 18 months, but then as other countries, we need to apply all other employment conditions. What I thought what it could be difficult for the country, it could be, for example, very long parental leave concerning, we have parental leave up to 3 years old of child, that after 18 months, the foreigner employers need to take this into consideration. And I will now ask the Slovakia whether they will take over.
Thank you very much, Nataša. Good afternoon to everybody from Slovakia. So let's discuss some very specifics of Slovak implementation of the directive. Beside the changes that were already presented to you, we have also very broad definition of all elements of payment. It's a very complex issue, and it's almost impossible to calculate it if you don't have inside info from the local employer how much he is paying to his employees. Why is it so complex? We have 6 different levels of minimum wage guaranteed by laws. We have also many benefits payments, like benefits payments for working weekends, night shifts, holiday shifts, bank holiday shifts, and etc. And there is also issue of minimum wages and wages guaranteed by collective agreements. Great news for you as if you are employer posted your employees to Slovakia or your clients are posting employees to Slovakia, you have right to get information on all working conditions from the local employer. It's great for you because you can also include it in your contracts, and then you have base documentation how much and what you need to provide to posted worker. Another important information is when everybody is discussing on short-term and long-term posting, how to calculate it, because we have also ongoing postings, and the Slovakia decided that the start point of calculating short-term posting is 30th July. So anything that happened before, we really don't care, and you must start calculating short-term posting and then long-term posting from this day. So that's all from me now, and I give word to the next speaker.
Yes, hello, it's me again, Sophie. I will not talk now about Europe, but talk about my own country, Belgium, and I can be relatively short about Belgium because the impact of the revised Posted Workers Directive all in all is not that big, and that for two reasons. And I think the most important reason is that since 2002, because that was the date when we implemented the first directive, or hardcore has already been defined as extremely broad, because since 2002 it's already the case that all terms and conditions of employment which are criminally sanctioned, and you must know that in Belgium almost everything is criminally sanctioned, applies as of day one. There is only one, or not only one, but an important thing which is not criminally sanctioned, and that is our Employment Contracts Act. Employment Contracts Act, where we can find dismissal laws and rules regarding sick pay and suspension of employment contracts. So basically, that is the main impact that the changes have, is that now this after 12 months that we also need to apply the things which we find in the Employment Contracts Act, and which come down actually to rules regarding sick pay. We have 1 month guaranteed pay, and rules regarding suspension of employment contract. And because all the rest already applies as of day one, also we have already since 2002 a very broad definition of remuneration. So all those mandatory elements of pay, they already apply since 2002 as of day one. So it's there we don't have many changes. In terms of calculation, the 12 months period, that is different as what we have heard from Slovakia. In Belgium, it is correct that this extended rules, or this extended rights, as I discussed from the Employment Contracts Act, they apply as of the 30th July to periods which longer than 12 months. But to calculate our 12-month period, we should also take into account the periods before the 30th of July. So it's not that everything starts from the 30th of July. For the calculation of whether or not we exceed the 12-month period, we need to take into account performances before that date. It's possible to extend it to 18 months. We can do this via an electronic form, where you have to also provide for the reasons. If you need this via electronic form, if you are also subject to a Limosa declaration, because you need to include in the form your Limosa reference. Limosa declaration is a mandatory declaration you need to do to Social Security authorities. If you're not subject to that, then you can just do it by email. For the rest, it's more or less copy-paste in terms of the allowances of what the directive foresays, or the presumption of reimbursement. Other thing which is new is an information obligation in case a Belgian company would use a foreign temporary agency. Well, then it must inform that foreign temporary agency in advance in writing of some essential terms and condition. And also if a Belgian user company would go with temporary agency workers, be it Belgian temporary agency workers or foreign temporary agency workers, would go himself to another country to perform services, for example, for a French client, then also there is an obligation to in writing inform that temporary agency, so that that agency can apply the applicable terms and conditions. This is criminally sanctioned, these information obligations, so important to follow. And then another thing that has been introduced is that I referred to the obligation for member states to provide information on websites. Well, it has now been foreseen if there is non-compliance with one of the posting conditions, but it was not mentioned on our website of the government, then this should be taken into account as a mitigating circumstance. So that was in a nutshell the main changes for Belgium and also for the other jurisdictions. I would also like, and now we can move to the next slide. So we had this kind of a first round I almost see as a speed dating session, because I realize that it goes very fast. I would like to go over for a next round where I would like to ask the speakers just to give them some key considerations if you would post workers to your jurisdictions, which can go much broader, of course, than revised posted workers directive, but just some kind of key elements we should take away if we send our workers to your jurisdictions. And there is perhaps one additional thing that I would like to add, because I saw in the question a question, what is a CBA? CBA is the abbreviation of collective bargaining agreement. I just want to, and we will take the other questions afterwards, but I just wanted to highlight that. So Anne-Laure, if you could just give us some key considerations.
Thank you. So France is quite similar to Belgium in a way that one of the key considerations to be taken into account is our way to calculate the 12 and the 18 months of period. I saw a question about asking when the clock starts to tick. And in France, you will have to consider the period before 30th of July to calculate the 12 or the 18 months of duration for the post-tick employment. So companies need to be aware of this retrospective calculation that Slovakia was pointing out earlier. So before extending the 12 months period, a declaration, a complementary declaration must be made on the CIPSI online service, which is a French website, which is already used for the initial declaration regarding the posting. And of course, before the end of the 12 months, and there is no detail on the reasons, but of course, the reasons need to be put on the declaration. There are some new rules also in the frame of the temporary work. From the 30th of July onwards, user companies established outside France and using posted employees by a foreign temporary agency to France have to inform the temporary agency before the beginning of the posting of the core rules of French law applicable. So they don't have to declare to the labor inspection anymore that the temporary work agency is aware of the posting of its employee in France. No declaration to the labor inspector anymore, but the user companies established outside France also still need to inform the temporary agency, of course, that its employees are posted in France. And in case of control by the labor inspection, the proof needs to be shown that this information was given to the temporary agency based outside France. There is also a new development regarding user companies based in France. They have a new obligation to inform temporary work agencies established outside France of the salary and conditions applicable to employees posted in France. Conditions regarding the remuneration, the labor code does not specify any other rules beyond the salary conditions. Regarding the criminal penalties, can go up to 4,000 euros per posted employee, and it can be increased in case of a repetition. But we do not have mitigation circumstances. The website, if it doesn't work, is not a mitigating circumstances, but the employer's good faith will be taken into consideration by the administrative authority, as it is already the case. So now let's move on to the next country, Germany.
Yes, thank you, France. So when you're posting a worker to Germany, the first thing that you need to consider is to carefully check which mandatory working conditions will actually be applicable. Because especially for determining which wages are going to be applicable to the posted worker, this can be fairly tricky. It's also important to check prior to the posting whether the posted worker will actually fall under any mandatory rules, because some particular groups of posted workers have been excluded from the application of some mandatory rules. Regarding the calculation of the 12 and 18-month periods from after which all rules will be applicable regarding working conditions, it's important to note that the time worked before 30th July 2020 does count into the calculation. However, existing postings which already began prior to 30th of July 2020 are automatically extended to 18 months, meaning that for a period of 18 months from the start of the posting, not all working conditions will be applicable, but merely the mandatory working conditions. As Sophie has already pointed out with regards to the general rules, it is highly recommended to regulate in the contract which regards the posting that posting allowances are considered remuneration and not reimbursement, because if this is not regulated explicitly, they will be considered reimbursement and they will not be able to be deducted from the reimbursement. An A1 certificate is highly recommended when posting people to Germany. And with regards to COVID-19 restrictions, it's important to note that there is an expanded duty of care of the employer to protect their employees from the virus. Additional checks could be expected in especially the meat industry, where there have been a lot of problems with the virus. And you must ensure to comply with immigration and quarantine restrictions, the latter of which, especially quarantine restrictions, vary locally based on federal state law. So make sure to check that before you post a worker to Germany. And now I give the floor to Hilda.
Yes, thank you again, Julia. I think before going into the key considerations, it's important to mention that the rules in the Netherlands will be applicable to, like Sophie emphasized in the beginning, the temporary posting. So if there's a long-term intention for a posting, example, a split salary situation, then it doesn't qualify as temporary posting. But on the other side, it also doesn't apply if you only go to, for example, Belgium or Germany on a business trip. So there needs to be an intention for a temporary posting over a couple of months. That is different in per country, though, so important to know that this is sort of the approach the Netherlands is taking. Now, a very important consideration, which I already mentioned before, is the fact that the rules on illness become applicable, which in the Netherlands means that you have an obligation to continue salary payment during illness for a maximum of 104 weeks. That's 2 years, so exceeding the 18 months. I know, but if an employee was to fall ill in the second week of the posting, and it was intended to last for 12 months, then you have will have an obligation to continue that salary payment. Also, that's mentioned before, I think, and quite clear now, that you carefully need to consider the allowances and do really specify the purpose thereof on a payslip or in the agreement on the posting. Existing postings prior to the 30th of July, what happens to them? Well, the ones that are currently not over 18 months yet will have an automatic extension to 18 months. So there's no need to apply for that or make a notification. That is fine. You're still fine if you are within the 18 months. However, if on the 30th of July 2020, this year, the posting already lasted over 18 months, it will immediately fall under the extended rules. So that's good to consider. Now in the Netherlands, we also have a notification obligation, which doesn't necessarily follow from this revised directive. It was an obligation there that was meant to be in there quite a long time ago, well, a long time, a bit before. We managed to introduce it per the 1st of March this year. It is important to do that. The law says that you need to make that notification obligation prior to the start of the posting. But an important element is that the receiver needs to verify this notification and whether it's correct. And if it's not correct, it needs to report that to the ministry. So that receiver needs to have time to verify that, and therefore it's strongly recommended to do it at least 5 days prior to the start of the posting. Preferably, of course, as soon as you can, but set a date at the latest 5 days prior to the start thereof. Then the non-compliance with all the obligations, not the ones mentioned here, but all the obligations, you can receive a penalty of 12,000 euros per violation, and that can easily accumulate. Of course, it remains to be seen whether the inspectorate will be as strict and per the first violation already, but do consider, take that into account, that the sanction can be quite substantial. And then I think the COVID-19 impact on the posting, which is obvious, this is all fine, but how does COVID-19 have an impact? Because most people have gone home and are working from somewhere else. Of course, we do see travel restrictions in the Netherlands. There are quite a few home working rules applicable to employers, which would also come into play in case of posting that needs to be complied with. And of course, it may well have an impact on the social security arrangements and wage tax systems in place. So it does require your attention, and it needs to be looked into whether or not some countries may have made some special arrangements on social security and taxes. For example, the Netherlands has so with Germany and Belgium. But something to be aware of and to carefully look into. And with that said, I'm happy to go to Sweden again. Peter.
Thank you very much, Hilda. And the key considerations for Sweden are perhaps not surprisingly connected to this issue with collective agreement. What you want to do first as an employer posting workers to Sweden is to assess which collective agreement that may apply to your business. You want to get an understanding of the terms and conditions that the posted workers may require. Like I said, the law says almost nothing about the minimum salaries, overtime payments, allowances. All of that is regulated through collective agreements in Sweden. And you want to get an idea, of course, about the cost that you're looking at. We have about 700 collective agreements on a central level in Sweden. So really important, of course, to identify the right one for your business. You want to be prepared for increased trade union activity in general, I would say. Make sure that your appointed contact person in Sweden is prepared for that as well, to be contacted and have a dialogue with trade unions about collective agreements, especially. I should also mention that, and something to follow up in near time, is that there are intentions by trade unions and employers associations to agree about adjusted collective agreements that specifically should be applicable to posted workers to make things easier given their special situation, although it's not yet in place, I would say. What you also want to do is consider working hours, especially for posted workers that travels back home to their home countries occasionally. Working hours is also something that is strictly regulated through collective agreements. And sometimes employers to posted workers schedule them on very long shifts in Sweden to give them more time off to go back to their home countries, perhaps. It is a good intention, but it may create a problem if any regulations in collective agreements regarding working hours, weekly working hours, or maximum shift working hours are violated. And reporting the posting, as I mentioned earlier, and what you also want to do is you need to inform the customer or recipient of the services that you provide that you have done this reporting obligation. The recipient in Sweden will be asked to confirm that by the Swedish Work Environment Authority, and the recipient will also be obliged to notify the Work Environment Authority in case you have not done the reporting. So there are, in general, more checking up and controls to be aware of for employers posting workers from now on. So Nataša, please continue.
Yes, that one good news for the Czech Republic is that we are counting the period of 12 and with exemption 18 months as of the July 30, 2020, that we are much more nicer to our to foreign employee than the other country, as I understood. What is very important, however, for the Czech Republic, that it's the reporting and administration obligation, which is very strict here. And nevertheless, how long the employees seconded from European Union stay here, they must, the foreign employer must report to the labor office quite a long application form. And also they need to have their employment contract in the Czech language. One exception is for Slovakia. This is quite difficult because the law do not differentiate between the secondment to provide the services and between the normal business trip, which is done for 1 or 2 days in the Czech Republic, and that's always the reporting obligation and translating of employment contract must be done even in 2 days business trip. True is that it's not very respected because the rules are very strict, but when it's coming to labor inspectorate, they could give you quite high penalty. What it's concerning, as I mentioned beginning, the one thing which is taking into consideration when the period of 12 or 18 months will be extended, that foreign employers will need to take into consideration the calculation of supplements which they need to provide to the seconded employee, which is all allowance for overtime, work at night, and during weekends, etc. Because most probably they will need to hire the Czech payroll lady to calculate for them as the calculation of average earnings will be applicable. And this is not easy calculation. We have no sanction for not having the A1, which is also good news, but I will recommend to have to come only with it anyway. And I will be happy to pass to Slovakia.
Thank you. So let's discuss some basic checklist, what to think about when posting employees to Slovakia. First of all, you have to choose right between business travels and posting. This is the really first step what to do, and if you misstep, you have be in a lot of troubles with respect to our Slovak authorities. So if you decide for posting, you have to you have to make good contracts arrangements with the host country employer, and also to know all working conditions that you have to provide to your posted worker. As I already said, the remuneration is very complex, and always think prior posting worker how much you have to pay to him or her when he is posted in Slovakia. Another hot topic in Slovakia is working time. We have really strict rules on tracking working time here. To get you a picture how strict we are, our standards, we can compare our standards to last year decision of Court of Justice in so much discussed case of CCO versus Deutsche Bank. We have to track every minute of our employees' working time, first minute, last minute. Also, we have to track overtime, night shifts, rest times, to really calculate whether they have enough resting time, maximum working time. Another important thing is A1 certificate and anti-social documents. As Nataša said, we recommend to pack your employee with A1 certificate. Next step, what to do prior posting your employee to Slovakia is notification to our National Labor Inspectorate. This is made in e-form through the website. It's also in English, so you should be able to do it in English. Through this website, we also notify all changes or extensions or if you decide to change the date of the postings. Another very important topic is visa and permits. If the posting is less than 90 days, you should be okay and you don't have to do any notifications. But after 90 days, your posted workers should get stay permit cards. So it will require some paperwork. Another very important duty is documentation. There is some retention obligations, so you have to keep in your files contracts, working time records, and proof of wage payments. This is also a GDPR issue, so be aware to update your information for your employees and also data records, how you process your data on your posted workers. With respect to COVID-19 restrictions, these restrictions are always changing, so please check it every time you are thinking about arranging postings and also prior posting, because most restrictions depend on the zoning of the country, and these days the negative test or 10-day quarantine is required. So thank you very much, and I give the word to Sophie.
Yes, hello. If you don't mind, I will very quickly say one word about Belgium and actually skip it, because I see that we are running out of time and I see we have many questions. So I would really like to concentrate on the questions. So what I want to say about Belgium is a bit the same like in all other countries. Watch out for paycheck collective bargaining agreements. And another thing which is important is that we have a prohibited lease of personnel issue. So if you send employees to Belgium, consider in advance how you will structure the posting, the secondment, because of our specific rules regarding prohibited lease of personnel. In addition, we also have a lot of formalities to do. We have limosa, social documents, and so forth. I will stop there because I really want to address some questions, because we have so many questions. And I would like, there is one question which comes back all the time. So I would like to address this to Nataša, because it is a question where Nataša and I have been talking about over the phone last week. So Nataša, one of the questions that comes here is, does the Posted Workers Directive also apply to business trips?
In Czech Republic, we are not specifically mentioned whether it's the business trip or not, because I'm talking now about the Czech regulation, that it's applied when you are providing the services, and it's question how, you know, how the employee is sent to the Czech Republic. Therefore, if they will provide the services that they are sending through the business trip, yes, it's applied to business trip too. But maybe the questions, it's the difference, Sophie, because they ask whether the legislation abroad is applied for business trip, because, you know, I have many questions that if the Czech employees are sending, for example, in Belgium, whether they need, or Germany, whether they need to also, you know, whether they need to have respecting the rules in Belgian rules, even if they are not provided services and it's only performance work on your territory. This is maybe the question, how it's stipulated now.
Mm-hmm. Yes, and actually what we want to respond to that is you need to check it by country, because if you look at the Posted Workers Directive, it is limited to providing services, meaning subcontracting, temporary agency work, and intra-group secondments. It's also mentioned as this in the posted guide that is being issued by the Commission, but actually member states can go further. So, for example, in my country, in Belgium, it applies if you temporarily work on Belgian territory. It is not limited to only providing services, whereas in the Netherlands, it is limited to, it's only in those cases where services are being provided. So the answer to the question is always look at the scope of application in the country concerned, and in some countries, it can indeed apply to also business trips. I have another question for France. Wait a moment, it was one of the beginning. So Anne-Laure, if you're ready. So the question is, for somebody on short-term assignment from Belgium to France, should we also pay the plan d'intéressement, which applies to employees on French contract?
Yes. Yes, definitely yes, because we have some case law dated 2018 saying that if there is a profit sharing scheme, which could be intéressement or participation, which is applicable to the local workforce, it should also benefit to the employees who have been posted to France. So yes.
Another question now that you're on for France, CIPSI is still required for meeting business trippers?
So I had a look quickly on the website. As far as I can see, it doesn't exactly specify that business trips should be declared. So it depends really if it can be connected with providing some service. There are some exceptions to not declare the service to the CIPSI, like a colloquium, symposium for researchers, artists, and other people. But I think in this case, it would be interesting to know what kind of business trip it is and the duration of it and what it exactly entails. So for the moment, it's not very clear on their website if it has to be declared or not.
Yes, thank you. Unfortunately, I'm afraid that we are already over our time. We will try to follow up on the questions, but also you can always contact one of the speakers and your user point of contact within Jus Laboris. I really thank you for your attendance. I also want to thank our speakers from today. I'm very sorry that in the short deadline we were unable to respond to all questions, but they are just too much to respond. But I hope that we have been able to give you some insights in those new rules, and I wish you a very pleasant day.